Time it being 6:30, March 26th, I'm going to start the Zoning Board of Appeals meeting with the Pledge of Allegiance. Pledge of allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. In accordance with Mass General Law, Chapter 38, Section 20F, this meeting is being recorded. The first hearing tonight is 0 Adamsville Road, administrative appeal of Cyril Delano, applicant, and Delano's Daily Grind Incorporated owner from the cease and desist order dated December 30th, 2024 by the zoning enforcement officer. Application for special permit pursuant to Article 14, zoning bylaw section 2.6 to place a temporary food service trailer, and a variance from Article 14, zoning bylaw section 5.1, table of use regulations. Subject property is located at 0 Adamsville Road, Westport, Mass, and shown on Assessor's Map 7920, Lot 21. And the way that we are going to...
Voting members?
The voting members, Janice Day will not be here because for ethics reasons. So the voting members will be those you see here: Jerry Catino, myself, Roger Menard, Ray Elias, Cynthia Kosekowicz, and George Stelios. Okay. Normally, what I do is I have the applicant come up
This way no one gets confused.
and present whatever information is pertinent. The board then asks questions to the applicant, and then after the board finishes that, I open it up to the public. I don't believe there's anybody here from the petitioner. Is that correct? You're all, okay. Because we did receive this from Gregory Estabrooks. This office represents the owners of Assessor's Map, Map 79, Lot 21, Delano's Daily Grind, the client. We are writing to inform you that after due consideration, we will not be attending the public hearing scheduled tonight on the appeal of the cease and desist order dated December 30th, 2024. We submit that this appeal is moot, and as a matter of law, the cease and desist order has been superseded in full by a subsequent decision from the zoning officer issued March 14th, 2025, determining the use is permissible. Thus, no vote or action from the zoning board tonight has any legal effect on the rights of my client. In addition to the decision, my client also received unanimous approval from the planning board on its application for a minor site plan on March 25th, 2025. Therefore, my client has the required status and approvals under the zoning bylaws to operate as a temporary trailer as defined by the zoning officer, and no relief is required from this board. In sum, the decision of March 14, 2025 supersedes the cease and desist order of December 30, 2024, and there was nothing in front of the board to act on. The board does not have jurisdiction to take any action. Respectively, whether the appeal is withdrawn, granted, or dismissed is irrelevant, and any adverse action tonight or attempt to enforce the cease and desist order, my client will result in litigation. So there is not going to be any discussion with the petitioner because they will not be here. What I am going to do, though, is I am going to read some of the background on this so we all know what's going on. So this essentially started with, let me get my paperwork here, a letter from the zoning enforcement officer, Ralph Souza, on December 30th, in which he said, Dear Mr. Delano, after a recent site visit to the property known as 0 Adamsville Road, Lot 21, Assessor's Map, Lot 79, it was noticed you have parked a food service trailer on the property with a full metered electric service where the trailer is plugged in. As per the Westport zoning bylaw table of use regulations, this use of the property for a food service trailer is not allowed. You may appeal the determination as allowed by Mass General Law 48. So that's what prompted the petition in the first place. What the attorney was talking about was a response then from Randy Bassett, who is acting building inspector during Ralph and Randy are both here, during his medical leave. So I will read that, because that sort of has bearing on the cease and desist. Again, dear Mr. Estabrook, this letter confirms our meeting, conversations and correspondence over the past few weeks. It concerns the use of a food service trailer on the property located Lot 21, Assessors Map 79, otherwise known as 0 Adamsville Road in Westport. Based upon the information provided to me and research I have done, is my determination that the food service trailer qualifies as an accessory use to the business as defined per Section 3 definitions. Additionally, temporary trailer use falls under Section 5.1 of the Westport zoning bylaws, is allowed by special permit from the planning board. And it quotes, accessory use, a use or building customarily incidental and subordinate to the principal use or building and allocated on the same lot with such principal use or building. In buildings restricted to residence use, the office of a professional man, customary family occupations and workshops not conducted for compensation shall be deemed accessory uses. There is no definition for temporary trailer in the zoning bylaws. Therefore, I look for similar laws in mass law. Under the Massachusetts Department of Public Health regulations, a mobile food establishment is a food service operation permitted under the Retail Food Code that is operated from a movable, motor-driven or propelled vehicle, portable structure, or watercraft that is able to change location. The term temporary trailer encompasses a food truck as defined by the Department of Health because both facilities focus on the movability of structure. It is temporary in the sense that it is mobile, not permanently affixed to the land, and is capable of changing location. While I have deemed the use permissible, you should proceed with any required approvals by the planning department and any other required agencies. This determination may obviate your need for appealing a prior determination by the building department and the use that was impermissible. So there is the conflicting view of our bylaw. We have talked to our attorney Blake since, based on this letter that we have received from the petitioner. We are going to continue with the hearing because we either have to reject it, approve it. We have to make a motion on this because it is before the board. We can't just ignore it. We do have to go forward with this. So what I'm going to do is we're going to first talk about, since it's really good that we have both Randy and Ralph here, we're going to go through why or why not this is an allowed use. We will discuss that first. Then after that, we will discuss other aspects of this, the variance and a special permit as required. Once we get done talking that, then I'll open it up to the public. You can, for your comment. So, having said that, now Ralph, you started off with a letter that said that it's not allowed use. You want to sort of
permissible use on the use table of the Westport zoning bylaw. Further, before that, I went out on surgery for January 8th. In this office, January 7th, the attorney and his clients, Jim Hartnett, myself, and the Board of Health agent were here meeting. And they agreed to go to this process, Board of Appeals. They were all set with it, they were agreeing to it. Next day I was all done. I was in Mass General in Boston. When I came out, that's when I heard everything changed. It's, going back the way I looked at it was, the main parcel in question is where the grist mill is. That's the home port. The lot across the street, not different lot numbers, same map, but different lot numbers. It's a lot, standalone lot. It's in a residential agricultural district. It's not in a business district. They're creating a business, regardless of the trailer. I don't believe the trailer would move in and out. I believe the trailer would stay there permanently. Because it was told to me that it was going to be the former operator of the Bond restaurant that closed that was going to operate it, and that's where he was going to operate his new business, because somebody bought the Bond, and they're doing something else with the Bond restaurant in the Little Compton side. so that he was gonna stay there. And they figured, I guess, put it as a trailer to start with.
They actually put power over to
They
it,
put
metered.
power over it, yeah. They powered the lot didn't have power on it, it was a vacant lot.
Right.
About 2015, it shows up on a map search as being, starting to be a lot, and in about 2017, 2018, it gets improved by gravel. They improve it with gravel, and that's already about the time the new owners took over the property. So in my view, I don't think that the trailer is protected.
Just for the general public, our zoning bylaws have what's called the use table. The use table is defined by district, whether you're in the business district or the residential. And in that, there's a list of the allowed uses for each of those districts. The preamble to that table says that if it is not specifically allowed, then it's not allowed. So I think that's part of what Ralph was saying, is that since he couldn't find it in the use table as an allowed use, then since it's not specifically allowed, according to our current bylaw, then it is not allowed. But Randy, I'd like to hear your side of this.
Sure. So, based on the information I received, I was going by that parking lot is used as a business use because it's been 10 years minimum, right, that it's been used as a parking lot for the restaurant across the street. So the food truck is an accessory use to the parking lot, which is already business. I understand that it's not zone business. However, it's been used as such for such a long time that that's where I'm coming from with my determination of that. So the parking lot is accessory to the business.
You're kind of grandfathering it in? Is that what
Yes,
you're saying?
because of the amount of time. It's been 10 years that it's been used as a parking lot.
Okay, but
So-
even such, where in the table of use does it say that they're allowed to have
So that's where I said it falls under the temporary trailer use under the zoning bylaws of 5.1 in the Westport. Because since there's no definition.
there's no
which is-
definition?
Yeah,
correct.
so it's not specific, right? So that's the best place I could slot it under. As per the definition and comparing it to the accessory use and the definition that you have of temporary trailer.
So we're trying to squeeze something into,
No, I'm just, like, this is how I interpreted it, and
Okay.
it's like, it's totally up to you guys, whatever you wanna do. That was my interpretation based on all the meetings that I had with them, and this is the decision I came up with.
And during this 10-year period in 2017, this was segmented into one particular lot, which took away from that, your thought process right there during that time.
I'm sorry,
It's a single lot now in a residential area, agricultural residential area. In the beginning, prior to that, if they hadn't excluded, in other words, made it a separate lot across the street, it's, because that's what you're thinking, right? And prior to that, I would say, yeah, that's I would agree with what he just said. But in 2017, they made it a separate lot,
Right.
which has to go by the same set of regulations as anywhere else in town,
You lose-
in
you
an
lose your
agricultural and
grandfather.
business
And that's-
district.
You lose your grandfather once you separate it.
what's that?
You lose the
You
grandfather.
lose the grandfather up to that point,
so why do you lose the grandfather?
because
You're not changing use, so why would you lose it?
Rezoned.
You're rezoning? Oh,
Yes, it was changed.
the zoning never changed.
No, not the zone.
He said zoning.
The lot
The
changed.
lot changed.
Yeah, but the use didn't change. So you don't lose grandfathering if the use doesn't change. It has to be for a period of 2 years or more where you lose the grandfathering status. Okay, like I said, that was just my interpretation. You guys do
Yes,
whatever you want.
yes. Yeah, no, I understand.
I'm not here to
I
argue
understand.
with you, I'm
It's,
just telling you where I'm coming from, you know what I mean?
Right.
Yeah,
I'd like to ask a different question.
Sure.
Regarding the 10-year, for a couple of reasons. Did you see physical evidence that that coffee shop was operating? When did it start?
the coffee shop started operating?
Yeah,
I'm not familiar with that.
so why would you think it was there for 10
Because,
years?
because when this is what I got from the owners, right? When they bought it, they were using that already as part of their overflow parking, or, because there's not a lot of off-street parking over there.
I'm talking about, when did the coffee shop start?
Yeah, but it does, if the use, so they didn't, if it's whatever business was in there before, they were already using that. So even when the coffee shop comes in, they're still using that lot. There's no change of use, because it's still the same.
There's difference between them using it and a legal, non-conforming use. okay?
But as the time goes on, it becomes pre-existing non-conforming, and it doesn't have to conform to the,
Now, you mentioned the 10-year.
that's because Ralph went back to 2015 where he saw it.
Okay.
Yeah.
Now, we have asked our town attorney about that 10-year thing. And what he has told us, we don't have it in writing, but what he has told us is that 10 years does not relate to use. It relates to structures. So in other words, after 10 years, if somebody's using it, you can't have them tear the house down or move it because it's too close to the line.
Statute of
or
limitations.
Anything like that. What's that, please?
Statute of limitations.
Yes.
Yeah.
But he said it does not relate to use at all. It could be 20 years or 30 years. If it's not the right use, you can do something about it.
That's fine. I disagree with that, but I'm just telling you where I came from with my letter.
He's told us.
Yeah, that's totally fine. He's entitled to his opinion as well.
So I don't think that there was ever any legal use. It never came before us at the zoning board for a change of use. To tell you how silly it is, the most recent legal non-conforming use where they came to the zoning board was back in like 1927, and they were allowed to sell vegetables and fruits on the buildings on the other side, the same side as the coffee shop is. And I found no records. Now, it doesn't mean they're not there or whatever, but there was no records. But when there's a change of use for a legal, non-conforming use, they are supposed to come before the zoning board for a finding that whatever they're wanting to do is not substantially more detrimental to the neighborhood. The other thing is, I would ask you, did you review any prior hearings that related to either the lot we're talking about across the street, or since they are admittedly using that as what they consider an accessory to the coffee shop, did you review any prior hearings before this board for the coffee shop, or for those properties at all?
No, they asked me for a determination on that property, and that's what I gave them.
Because there are 4 or 5 hearings that have been held on that property. And there were restrictions put in there. There were concerns expressed about the safety of that road, the lack of parking, all of that. That was all discussed at prior hearings before this board. And those are all on the record. So these all kind of relate because they're relating it to the coffee shop. The property that we're talking about was at one time, long ago, used as a lantern shop. I guess they sold and repaired lanterns. But that non-conforming use has long expired. So I'm trying to find out what the justification is for us to find that any kind of business use would be legal in the sense of either non-conforming or just as a variance to start out new with a business use. Anyway, I'll leave it at that for the moment.
Anything else from the board? You got comments on the
I
cease and desist?
guess I got a question. for procedurally, is it procedurally correct for a zoning enforcement department to renege on the cease and desist while an active appeal is pending on that
Well,
cease and desist?
We've never been through this before.
Never had that
And
happen.
I understand the
For
situation.
years that I've been doing it, it's just, this was a case where I made my determination.
Yes.
It was agreed upon to come to this board.
And they filed the appeal, and then all of a sudden, there was a sidebar done that, yes, for right or for wrong, perhaps made the original one moot, but I don't think it was, because the appeal was still pending.
Right,
They
and I-
they didn't withdraw the appeal. They
Right.
still haven't withdrawn the appeal.
Correct. So what our job is to there are three sections of this. They're asking for an administrative appeal, a variance, and a special permit. And we're going to have to essentially act on those three separate parts of the petition.
During the meeting that Ralph discussed, or said, right in this, yeah, the town administrator states that the food truck for the Daily Grind is located on a newly residential zone parcel created a few years ago as a non-buildable lot and would need a variance to operate a business in a residential district. That's what his comment was. And I still say that that's a new law. It's in a residential agricultural district. And if we allowed this, even if we just made this a special one, what are we opening up throughout the community for the same kind of thing to happen?
I can make my property a parking lot and charge money for it. And, if I live next to the beach where there's always a parking problem, what would stop me from putting a little sign out and having parking and having people pay for it? I think that would be stopped, and I think having a parking lot and on a residential lot needs a permit.
Well, the parking lot was being used as a parking lot prior to the separation of the lot.
Yes,
Right,
but once it got separated, it lost, once it got
doesn't,
separated.
because you didn't change the use.
But not necessarily used as a business.
No, but it's an accessory use to the business.
Well-
That's why the parking lot was there.
you could park there and you could go to the business, but it was also used for people to park by the water and watch.
Oh, yeah, and they're not looking to take that away.
So,
Yeah, yeah.
you know,
But it's still a parking lot.
and when
Great.
Mr. Gill redid that area, he was trying to make it so that it was kind of like original
Yeah.
and so
To
forth.
try to get people access to the pond.
Right, and he wanted, people to enjoy it as a recreational area and so forth. We have that in writing from a prior lawyer, that was
Yeah.
what his intent was. And do you know the date that these folks bought this property?
I don't have that off the top of my head, no. I don't know.
It's only been a few years.
That's what I'm saying. was
Like, it's only been
Was
like
it-
2 or 3, it's been only about 2 or 3 years.
Not more than 10,
No,
as he was indicating.
it's about 2.
No, I'm just saying, based on Ralph's statement, that it's been used as a parking lot for 10 years.
It was in 2022.
Okay.
Is when the Daily
10
Grind
years.
bought it. No, that's when they bought it, but it was used prior to that as a parking lot.
Well,
Like
that's
I
why.
said, it's just my opinion. You guys, you make up your own mind. I'm not here to argue the points.
No, but
I'm just
now
giving
it's
them to you.
leading to much more.
Okay.
And,
Well, it led to the applicant not showing up tonight, which I find highly disrespectful, considering that there's all these people in support of this business, and the business didn't even have the courtesy to show up today.
no, I would like to just insert at some point here, we have a lot of people here. We have pages of people who are supporting this thing, okay? And that's wonderful. And some of us personally might also want to support it. But this board has to go by what the rules are and what the law is. Otherwise, why have them if we don't adhere to them? So I just want to be clear that we on this board not running a popularity contest for either ourselves or a business. Oh, you like that business, so let's support it. I don't like that business, we won't support it. We have to go by what we find in the evidence written, what's in the bylaws, and so forth. And as was mentioned earlier, our bylaws work in such a way that if it's not specifically addressed in the bylaws, it's not allowed. If you want it to be allowed, then you go through the process of getting the bylaws adjusted so that it meets what you want it to meet. And you could still do that if you choose to. But I just want to let you know that there's lots and lots and lots of people who are supporting this.
Right, I'm going to go through some of that documentation. The other thing that you all should understand is exactly what is an administrative appeal. An administrative appeal is, in this particular case, Ralph Souza, who is the zoning enforcement officer, sent essentially a cease and desist letter to the petitioner, saying that you violate the zoning. The petitioner doesn't agree with that. Petitioner says, no, I don't think I violated zoning, so Mr. Zoning Enforcement Officer, we think you're wrong. And that's what the administrative appeal is. They are essentially saying that they do not believe that the zoning enforcement officer correctly enforced the zoning bylaw. And that's the only thing here that we, whether we vote in affirmative or negative for that part of the petition, the only information that we can utilize to make a decision is to look and say, did he correctly enforce the bylaw or not? Not whether we like it, whether we would like to go forward with the project. It has nothing to do with was the bylaw enforced correctly. And so that's the first part of this. And then we'll get into the variance and the special permit later. But I sort of wanted to get that out. This is a black and white. Either we enforced it correctly or we didn't enforce it correctly. And that's what we'll talk about in a minute. I do want to read just one from Sarah Delano of Days Really Grind. She has a lot of back information. There's literally hundreds of people that said they really, they're really for this. We did get a couple of emails saying that they were against it. But the vast, like I said, we have a petition of literally hundreds of names. I am going to read this. It sort of gives a little background on what this project is all about.
Who is that again?
The owner of the property, Sarah Delano.
Sarah Williams.
Was that part
Part of the package.
That was part of our original?
Yes,
Okay.
part of Exhibit A.
I'm familiar with that.
So I'm going to read this because it just gives a little background. The co-op food trailer has been positioned in an area that was previously cleared, set as far back from the road as possible without disturbing the natural environment. The old stone wall remains intact and previously dilapidated gate has been rebuilt to enhance the site's appearance. No new driveways or entrances have been created, and the old one remains the same size. Throughout the season, we maintain the lawns and the gardens of our property weekly, mowing, manually collecting fallen debris, ensuring that trails and walkways are free of potential hazards. We do not use herbicides, pesticides, or fertilizers, and we maintain a complete natural space. We continually enhance the green space with native flora and pollinator-friendly flowers and shrubs. To ensure the most peaceful use of the space, we decided to apply for a permit to run electric wires underground to run the food trailer. There is no noise pollution, no propane gas, and no obstructed views. Permitting the food trailer to operate for several hours each morning should not negatively impact the flow of traffic in the neighborhood. Quite conversely, by utilizing the limited number of available parking spaces for a longer period, we would be decreasing the number of people in and out of the lots. Seating in the area also allows patrons to eat and drink while remaining stationary, which decreases the likelihood of distracted driving. Moreover, allowing the food trailer to operate would encourage customers to spend more time in the parking lot, allowing them to explore the passive recreation area and learn about their surroundings. They would observe local wildlife thriving in the pond, such as otters, turtles, frogs, trout, blue herons, ospreys, white egrets, geese, et cetera, et cetera, et cetera. Visitors will learn about the fish ladder that rises through the dam and observe the fishery's impact on the ecosystem. They will also notice that the pond is used by the fire departments of Westport and neighboring towns to combat local fires, as indicated by the special attachment for fire hoses along the road. They will observe stone walls and native plantings, as well as learn about the natural path of the water from the pond as it flows towards the coast of this beautiful town. As patrons walk back to their cars, they'll notice the expanse of land on the curve of Adamsville, and the curiosity about the Westport Land Trust may grow, potentially leading to increased donations and greater public interest. The general use of the lot will not change. For many years, its primary purpose has been parking, and that will continue. It will remain the space and equipment to ensure that patrons and public alike can enjoy a clean, natural environment, Sarah Delano, Graves Daily Point. So I wanted to read that because it sort of gives a little background on this particular project. I'm certainly not going to read, 30 pages of people petition to either approve or disapprove. But it is all on public record. The other aspects of this, Ralph, they're also asking for a variance and a special permit. And the variance is for use? The use variance. Now, if we were to reject the petition on the appeal, meaning that we agree with your initial determination, is the variance and special permit still valid, or would they be treated separately?
They'd be treated separately.
Okay. So even if we disagree with their appeal on the administrative appeal, we could still go past and either grant or reject the special permit, the variance, because the variance is a change of use variance. Okay. Any other?
Wouldn't we need the petitioner here for the variance?
Yeah.
No,
Oh, no, we can.
No.
Yeah.
I wouldn't say
No.
so.
no, they don't want to come, they don't have,
And that alone would mean that unless we found something in this paperwork that complied with the hardship requirement, the topography, et cetera, if it's not in here, we couldn't pass a variance.
So what they describe is that they want a use variance. The lot is unique, unbuildable, and not suitable for residential use because adjacent, pond. Little enforcement results in substantial hardship, requires use by owner, who also owns Gray's existing non-conforming business, for parking, recreation, and extension of commercial use. It's consistent with the condition of the neighborhood. One of the things that is required for a variance is a hardship, but the hardship has to be based on some aspect of the land, like there's a ledge that you can't build on, or there's a stream running through the middle of it, or whatever. They sort of hint at, I assume that their hardship would be based mostly on, I have a hard time saying that the adjacent pond is really a hardship, but that would be the only thing that I could even, there's nothing in their description that describes what the hardship is, other than enforcing, a literal enforcement of our regulation causes them a substantial hardship. Well, that's,
Well, just bear in mind what was said earlier. When they divided that lot, it was clearly stated it's a non-buildable lot.
non-buildable lot, correct. Right. Then there's,
Mr. Chairman, do you want to continue talking about the variance at this point, or do you want to take the first half of the thing?
I suppose that what I'd like to sort of is get the cease and desist order out of the way.
That's why I'm asking.
And then, so that we can continue with that. Does anybody in the audience want to discuss the cease and desist order? Not the, okay, because that's, like I said, that's a yes or no, that's a, how do you interpret the bylaw? Yes, go ahead, name and address when you come up.
David O'Brien, 374 Cornell Road. Miss Ralph, I'm not remembering your last name. Souza. One of you had asked how often a cease and desist had ever been done in town. Is that a common occurrence for this sort of situation?
Well, a cease and desist order is
Quite common.
quite common for a variety of reasons. So this isn't unique.
Okay, but coming from that position to a person who might be an applicant, it's not uncommon to just say, stop what you're doing.
Correct.
Okay.
What's uncommon is the fact that it was, after the appeal was filed, that it was reversed by the acting zoning enforcement.
Right, which
Like
is-
Ralph would, if Ralph had still been in, and not been on medical leave, I would severely doubt that anything that they brought to his attention would have reversed his decision. He would have waited for us to rule on it, and he would have, as he is tonight, would have come and would have, if he thought his decision might have been in error, he would say so at that meeting, but he would let us decide. And
But
that's
there-
what I was asking. I don't, because I'm relatively still new to the zoning board, only a few years, and I was asking Jerry if at any different time has this happened before, and
I
to
can
his-
speak to
my-
that. It does happen quite often. Anytime, anywhere, anytime there's a,
no, I mean here, Westport.
anytime there's a new commissioner in, right, everybody hits them with the
Yeah.
same stuff.
Oh,
But I'm
sure.
There's a
saying West,
different
Yes,
interpretation.
different interpretation.
So
Yes.
that's why that happened.
Yes.
So it is common.
But as it relates to the appeal, there was in fact a memorandum issued to the property owner to say, you can proceed. Is that correct?
Yes,
And with that memorandum to proceed, that person, the individual, the couple who own the Gray's Daily Grind, spent money, invested in developing their business, and,
no, it was already there.
It's a timing issue.
okay, it's a timing
That was
issue.
just
It was just when you're talking about.
2 or 3 days ago.
Okay, and this may be later in your 3 bullets that you have to deal with, but this is not a popularity contest, and I admire you all for taking on what I assume is a volunteer position, so thank you. As a new person to this community, thank you for what you do. I guess my basic question would be, well, it's not a popularity contest, do the committees in town, and do we as citizens and voters in this town, are we pro-business? Do we want to expand businesses? I think that matters. And to the extent that there's an opportunity to expand an existing business, I think we should be all for that. I get that there are rules and there are procedures and steps and process and that sort of thing. But the timing issue strikes me, just since I've been here, as there's got to be a way to fix this.
Yeah,
And
there
if-
is.
And if
Yeah,
part,
Change the zoning
Mentioned it
laws.
earlier.
and if part of what we're doing is to try and let this one business expand and make a variance for this one, and I hear you on, well, if you do this for this one, we're going to have to do it for everybody. Change the zoning law after this, but there's a variance opportunity to be had here, and I hope you take it.
No, there's a difference here, but we will get to the variance part of this.
Yeah.
Because that will be a change of use. The cease and desist part of this is straightforward. Either we agree that Ralph correctly administered the bylaw or he didn't, yes or no. So that has, that's not a business sensitive, that's just, did we interpret the rule correctly?
Right.
The
So
other aspects of this are a little different.
if I don't know your last name, I'm sorry. If
Bassett.
Bassett. If Randy Bassett issued a memorandum and Ralph was on medical leave,
And
isn't that the indication to the property owner and the business owner to proceed?
yes, and then about 2 days later, it was, Ralph sent out another email saying that, no, I still believe that this is not a legal use.
Right, so that's going to be decided in,
And on top
Or
of that, the
maybe-
site plan got approved at the planning board last night.
right,
They
4
can't
to,
approve,
4-0, correct?
They can't approve the use.
Okay, but that got approved, minor site plan change, 4-0.
both Jerry and I attended.
Right, right. Okay, thank you.
Any other comment on the cease and desist? No.
I generally agree with having a business there. I'm a business, I worked 48 years next door at the supermarket, so I'm pro-business. And this food truck thing is gonna be around. It's in the local communities, approved on a regular basis. If we were across the line in Dartmouth, this would be okay. I'm just
Or if it
assuming.
was on
Okay, if
Route
we were in New Bedford.
Route
They-
6 in Westport. would be
Yeah,
okay.
they talked about this at the planning board last night.
They do it at the vineyard.
Yeah.
That's at the Westport Vineyard. They have the.
That's a
food
farm.
truck there.
That's different.
It's a farm.
That's a
That's
farm.
allowed. That's an allowed use.
It's a,
It's under.
That's agriculture and tourism.
agricultural exemption, yeah.
That's a specifically allowed use.
But I guess my point is,
lot, right? It's residential, but it's not
It's residential, non-buildable.
used
Surrounded by businesses.
breeds across the street.
Yes, roughly, yes.
that were all there pre-existing. They were all there, like Jerry said.
Ralph Guild was using it for parking,
Excuse me?
Mr. Guild was using it.
yes, but, and he also has a stipulation that it's supposed to still be run as a mill, and it's not.
Right, and the
Everybody's
parking,
feelings hurt about that. That's the real issue.
That's,
We have no,
Real
fe-
issue. Everybody's feelings.
Okay, we really can't.
we don't have any feelings
Okay.
about that. We have feelings about our
We really
our
can't
bylaws.
be dialoguing back and forth. If you have something to say, we have to go to the mic.
and we're dealing with the cease and desist at this moment. We'll get to the other part after.
Right, but I really can't close the hearing, Jerry.
No.
Until we get all three of these discussed.
I wouldn't want to close it here.
We have no comment.
Myself, I don't.
Yeah, I
don't
have a
feel-
comment.
Depending on what we hear, I don't see any reason to close the hearing tonight, because I
No, we're
think we have
closing
to.
it, we're closing it tonight.
Well, you can
Yeah.
close it tonight, but I
There's-
think.
because there's
we got some-
nothing-
We've got some definitions that need to be, I said, depends on what we
Yeah.
hear tonight.
Okay, so we're going to move on and discuss the,
We have somebody that wants to.
I'm
Stephen Bates, I live in Dartmouth, but I shop at Lee's and I go to the Daily Grind. I'm just curious that when the interim director issued a report.
rebuttal.
Yes, that when Ralph sent an email, does that negate his opinion?
It depends on how you look at it.
Oh, that's
That was not.
above my
That's
pay
not an
grade.
official letter. They both sent official letters, and that's really what the lawyers actually go.
As interim, he has full authority.
Yes.
And then the email, while he was still on leave, is an opinion.
You know, he was back from leave.
Go ahead, Ralph?
He was back
Judge.
The email was sent while I was on duty.
on duty? Okay.
Okay.
What about the fact that it's a trailer?
Excuse me, would you speak at the mic, please?
Absolutely. Matt Santos, Main Street. What about the fact that he's assuming that the
Main
trailer's
Street,
not
what
gonna
town,
move?
please?
Westport?
Well, that man just from Dartmouth, so I can't assume.
Take it easy, please.
I think you should take it easy.
All right.
You're all,
Everybody take.
no, you're all assuming we're gonna vote some way, and you're actually getting very hostile to us, which is actually, in my opinion, making me wanna vote the way you don't want me to vote.
Okay, let's.
Sounds very
calm down.
professional.
Calm down. Go ahead.
Part of what Ralph said was he assumed that this trailer wasn't gonna move anymore as part of his decision. Who is he to assume that the trailer on wheels isn't gonna move anymore?
Okay. We're talking about cease and desist order. and that's-
cease and desist order.
Yes, so,
Ralph,
Ralph, go ahead.
There was an expensive, elaborate service put on the property for that trailer.
Electricity.
The trailer wasn't gonna move.
Yeah.
Who approved that?
Nobody.
Again, speak at the mic, please.
Who approved the electrical service permit to be put on the property?
The electrician pulled the permit through my office and he got it. He shouldn't have got it.
And then, but N-Star or whoever, went and put a new pole in and then ran the service, and that was an expense, I think, of several $1,000s.
Okay. Okay, we can discuss the variance aspect. And once again, the only information we have is what was handwritten on the application. The use variance, so the use variance means that that it started off as something and we're varying it to something else.
Because we are.
Okay,
Are we still on cease and desist?
no, unless you got something else you
Well-
want to,
What I would say is that Ralph reviewed bylaws, and by the way, there are town bylaws that affect food trailers, okay? But there are no zoning bylaws that affect. So Ralph reviewed the zoning things as a zoning enforcement officer, and he did not find anything that said that you could operate a food. So from that point of view, I say that he did the right thing.
right, and we'll come to a vote on that after we get done with, because we can't vote on these things separately.
No, we're not.
Well, we can't vote until they close the hearing.
For Jerry.
I know it.
No,
I mean, I'd love to vote on these things all separately and close the hearing separately, but they really, technically, we can't do that. We have to, we actually have to hear all aspects of it, but we vote on each aspect of this separately.
Roger,
Yes,
just so I understand it, you granted the electrical permit?
The officers, the electrician, licensed electricians come in and pull a permit. One of the secretaries writes the permit out for them, so we're all online now. This has been back when we wrote permits out. So the permit got written out. By the time I found out about it, it was already in place, already in the ground.
So that
The
was,
service was already in the ground.
so that was,
That's when the trailer showed up. And the trailer got plugged into the service.
but if your office, not you, but your office approved the electrical, then if I was him, I would think that the next step
Right,
is,
but there's been other incidents that involve that property that have come through my office that we've had to stop in the past. This isn't the first hiccup over there.
I'm sure that every electrical permit, plumbing permit, or whatever that is applied for in the building department, they do not research the zoning bylaws to see whether that particular property would pass muster or not. There's no way they could do that. We've had that happen on occasion in the past where we had some units, all had to come before this board, conditions were placed, people go to the building department from that complex, apply to put a, let's say, a toilet on the second floor, and they don't know, unless they had to research every piece of property coming in for a permit, they'd have to research it and see what the zoning board, did it come before the zoning board, and so forth. I've been trying to get for years where we'd have a town system that showed each property if it came before this board, so that it would be at least a heads up, so that they would look further. But in this case, it wouldn't have mattered, because this particular lot has never come before this board. But the other ones have across the street that they're using as an accessory connection to do it. And as far as the parking on there, when Mr. Gill had it, his idea was so people could go there recreationally and park and watch the water and watch the animals and so forth. I don't think it was necessarily for the grist mill or the Daily Grind coffee shop.
But it was a parking lot.
It was parking.
Okay, so the other thing I want to speak on that electrical permit, anybody can put an electrical permit, they can put a pedestal wherever they want. Whatever they do with it after that is irrelevant, right? They followed the correct procedure, they filed for a building permit for electrical permit, I apologize. They got their permit and they did what they said they were gonna do, with all applicable inspections. So there's absolutely no problem with that electrical permit being issued, I just want to clarify that.
okay. Thank you.
Mr. Chairman?
Yes,
David O'Brien, 374 Cornell Road again. As part of that permit being issued, Was it then inspected by the town?
Well,
The electrical inspectors.
It was?
yes.
Okay, so they issued it, didn't agree that it should be issued, then it was inspected and approved?
So like I said,
That's-
anybody can pull an electrical.
Right.
I get that.
Pedestal on your property. We don't know what you're gonna do with it. It's up
Right.
to you.
Yeah.
You can what you do with it after that.
But
I
it's
can put one on
inspected
my
after it's
property.
installed?
The trench gets inspected. There's
It does,
full inspection.
so
Right.
Yeah.
they
So all
played by the
all the
rule.
electric permit does is it makes sure that you complied with all the codes for electrical.
Right.
That's all they care about.
Yep.
They don't care about what you use it for.
Okay, so they
And
played,
it's not a zoning issue.
but they played by the rules for the permitting for the electrical with the understanding, based on what I understand, that they were going to try to put something over there, like a trailer. They weren't lighting a parking lot,
Well,
so they were putting a trailer in, because my understanding is they told the town they were doing this. They didn't pop the
No.
trailer out of thin air, did they? Was that not understood?
yes.
There's nothing in the record to say that they didn't.
Okay,
They asked for lighting, and again, that was with the building, there's the electric department, so there's the building department, and Ralph is the building inspector.
yeah,
Then there's the electric department, under that, there is the electrical inspector and the plumbing inspector. Different individuals.
okay.
And they
Ralph, as the building inspector, he also wears a second hat, which is the zoning enforcement officer, and that was, wearing that hat is when he issued the cease and desist.
Okay, thank you.
And they certainly did not know that not only that they were going to put a trailer, but that it was going to be running a business. There is a difference.
They already have the business, it's an extension of the business for the interim,
That's what they're contending.
for the interim director was an extension of the business,
That's what they're saying.
not me.
But I
this man here.
have already asked tonight about the length of time. And there is a question about that, because you can't just start a business, run it for a couple of years, and then, oh, I got a legal non-conforming business. Not true. That's why I use the term legal non-conforming.
Of my pay grade, yeah.
We have a fair amount of that in this town.
Yeah, I know.
Hey, my name's Nicole Wardell. I've been a resident of Adamsville, 29 Main Street for 30 years. I'm a patron of the Daily Grind every day. I also went there when Mary Miska ran it. I think that property is zoned commercial, correct?
No, residential.
No. So I used to do farmers markets there. Is that one of the issues that they had beforehand of doing over there, or was it other things?
What do you mean by that?
Well, someone had said that there was issues with other,
What did you run there? You said you ran?
they had farmers markets at different points, and I am basically 7 driveways down from the Daily Grind, and I sell culinary herbs on the side of the road.
Where was the farmer's market?
It was in the parking lot.
This lot.
The parking lot, there were horse rides, there were,
Before the current owner.
right before, yes. Yes. And just, I think it's a brand-new Airstream. It's not, it looks quaint. It doesn't look like, someone pulled it off of the side of Sanford Road with mildew all over it. It's, the issue is that it seemed like Mary and her husband, Mr. Simmons, could do whatever they pleased there. And this seems that Sarah and Bruce are getting nothing but people trying to block everything they're doing to increase their business as small business young owners. And for me, having a stand there, if they don't have, we don't even basically have a breakfast restaurant. The only thing in Little Compton is Commons Lunch, and that's for sale. We lost Gray's Store, we lost Simmons Store, we lost, the barn, everything. So to make breakfast sandwiches in a little trailer that basically the whole neighborhood has no problem with, whether it's on Rhode Island side or Massachusetts side, but there's nothing to draw people to town anymore. You know what I mean? It's like a ghost town.
Aren't they redoing the other one?
They redid it, and now they're tearing it down because the woman had bought all the property up to the post office, but that has nothing to do with this, and she also
No,
bought the
but it
barn.
has to do with, you said there isn't anything more. there.
Yes, there's nothing, basically.
So they're not gonna redo that? Where,
They redid it, but now they're supposed to rip it down.
yeah,
Af-
Morton used to make the ice cream.
Yes,
Was there horses at the farmer's market before?
yes, there were.
But the issue here now is that property is now zoned as residential, and they want to run a business on residential property.
So,
That's
it-
where we get into conflict, because when you look at the use table, it doesn't, there's nothing in there that says you can do that.
so this was at one point commercial residential?
No,
No.
no, never was.
Never was.
But the thing of it was, you could run a farmer's market there as well, and unless someone complains,
Right.
we're never gonna hear about it.
Yeah.
But once somebody complains or brings a thing like this, that's when it has to come. But yes, your farmer's market probably would have had to come before this board.
But I
As a
know it didn't.
commercial item.
Yes.
It didn't. So, because they just asked me to do it,
I'm
and,
sure it's a day permit.
So you were violating the law.
well, I didn't know, because, I live in the country, and I thought it was, you could sell on the side of the road what you grow or cook in your own house.
Well,
I grow culinary herbs, and I sell them on the side of the road.
And you can do, right, and you can do that as a farm stand on your property. And
Yeah.
remember now, farms have quite a different set of
Yes.
bylaws.
See, the thing is, it's like, it used to be the old Tabor Mill, which was my family from Westport, and the Manchesters, and I'm a Wardell. So the thing is, and it's not by marriage, I'm a true Wardell. And the thing is that there used to be, penny candy here, shopping here, this here, and it's like, I don't see how they could get a smaller, Airstream to, not be visible over there. Who are they really hurting?
Can I ask this question to everybody here? You're here all in support.
Yes.
And that's great. Great to support our own businesses. But don't you find it a little odd that the people whose businesses are here are not here? No, they still need a variance.
But I mean, maybe the
No.
lawyer told them that.
Well,
All the workers are here.
yeah.
Of course.
But I'm saying is that in addition to there's, as the chairman has says, there's 3 issues on the plate tonight. Was Ralph cease and desist legal or not? 2, regardless if it's legal or not, they're still asking for a variance, which they're still gonna need because it's in a commercial, it's in a residential zone. So at minimum, they should have been here for the variance and the special permit,
And the
at
thing we're
minimum.
talking about, that happened prior to all this, is prior to them subdividing that lot. That lot being subdivided causes it to be separate from everything else going on.
See, I mean, I was under this understanding since a long time ago that basically everyone on Main Street to F.E. Brayton's was commercial residential. Our house is commercial residential.
Well, we don't actually have commercial residential. It's either commercial or it's residential.
Yes,
You can't be both.
okay. So,
When
no,
you're commercial, you can have residences, but if you're a resident, you can't have commercial.
yes.
Well, if most of you have probably been to Bittersweet at one time, that's that's not in the residential, that's not in a business zone. They had to come here for this,
They had.
which is similar to what we're talking about.
But the thing
Not
is,
in the business zone.
they have to come here for alcohol, they have to come here for food, they have to come here for
No, they
basic.
have to come here to even establish a restaurant.
Okay, but say the other half of the building that you guys aren't letting them use to let people go in and enjoy their coffee. I've seen this space with pictures. There's, a window along the whole back wall with stools that look out over the back. How come they can't have people sit in there and drink their coffee?
That's not us, that's not zoning. That's probably the building office or perhaps the health department.
Ralph?
Ralph,
They've been told that they could do it if they came here and change a finding. that the use of that area would be more detrimental to what's already there. They refuse to do it.
Well, I mean, the thing is, I'm sure there's a reason that Bruce and Sarah aren't here, because they are stand-up people and they would show up to a meeting. I mean, they must have had someone tell them maybe it was better off that just the people that signed the petition came. We can't guess why they're not here,
No.
No,
but
I didn't ask you to guess. I just wanted to state the point that
It's
they don't
unusual
even feel.
for that not to happen.
Okay.
This is unusual.
Let's keep moving here.
yes, okay, thank you.
Anybody else?
Yeah, could I address her?
I didn't really open it up publicly, but we did.
I just want to say, I said earlier about changing, try to get the rules changed. Well, I want to let you know something. For the last couple of years, I've been discussing with the planning board. They're the ones who originate most of these bylaws. And we've been talking about trying to get some, what we're calling village zoning in this town. The head, the intersection of Southwest Port, which is where the gas station is, the Hicks Bridge and so forth, Adamsville, and so forth. The villages, what used to be villages, and get special zoning for them to put little things like you're talking about, a small coffee shop, or even a gas station if it's necessary. And we've been talking about this. We talked about it again last night after the meeting, just informally talking about it. But they've got so much on their plate over there, and they've only recently gotten a planner and an assistant planner. So what I'm going to suggest is that all of you go to the planning board and talk that up and say, that's an area that would be perfect for this, and then you could get what you're looking for.
Can I ask another question? For those who are Westport residents here, who goes to the annual town meeting? Not that many.
That's where.
That's
we
where
put
this
these
change, that is where we can change things.
That's what happens.
And-
Well, you got to
and
go
I-
to the planning board first to start the warrant article, but yes, that's where it really matters.
I said originally that we had three aspects of this. I'm going to jump ahead very quickly to the special permit part of this, because I think we can resolve this very quickly. It is a special permit for a temporary trailer, which is allowed by, and I'll give you the code, Y/SPA-PB. All right, what that means is, yes, it's allowed. You need a special permit from the planning board. It shouldn't even come in front of us because we are not authorized to act on a special permit for the temporary trailer use. So
But could I also say,
that part of it is not really under our jurisdiction.
this is not a temporary.
What they're asking,
Really?
I know, if they're
It is.
asking
but
for
they're
a
tying
special
it to
permit for a
that.
temporary
When they
trailer.
met with you, they tied that to the temporary trailer bylaw. It's the only bylaw that even comes close, and it's not very close. But this is not meant to be a temporary anything.
Well, temporary means it's movable, not permanent.
Yeah.
Right,
So
It's
therefore, the
movable.
trailer is
it
temporary.
is movable.
So
Yeah.
we can argue that one if you want, but that's how it is.
But that means that it can be moved,
Yeah.
but it's also got to be moved out. I'll give you a quick example. Our town bylaw, not the zoning, our town bylaw has one place in there where they're allowed from 1 day to 14 days within a 30-day period. They're not
That'd be
meant to be
stipulation based-
staying there.
Based on the planning board's decision, wouldn't it?
I'm sorry.
Right, and
Planning
that's
board would
where,
put that stipulation on there, because it's a special permit through them,
The-
as far as number of days, et cetera.
No,
Correct?
I'm talking about our regular town bylaw, which also is enforceable,
Right, but that, okay, yeah, it's,
not as a zoning, but.
no, yeah.
okay, name and address and,
Thank you. Valerie Bassett, 592 Adamsville Road, and I think my wife Paul and I are the closest abutters to this property. We're right on the corner of Quail Trail. I think there's so many layers of what's going on here, but I wanted to echo both what Ms. Wardell said and Mr. Coutinho. for the issue that it's sort of surreal to be talking about this as a residential neighborhood, because apparently all the commercial businesses there must be grandfathered in. And, going back to the 1600s and the mill, the sawmill, the ice plant, bakery, grocery store, market, general store, the lamp store. So we're in a kind of very artificially constructed situation, so I understand your constraints. I do think probably the route is to get village zoning, because the garage is, if anything, more of a public nuisance than anything we're talking about here. But it's not a zoning issue.
But it's grandfathered.
Exactly. So it's a kind of surreal contradiction between what is grandfathered and then what is facing the current restricted zoning. Part of the appeal of living in Adamsville is all that you can walk to, these businesses, as well as the natural beauty. So, I certainly hope that the committee will take that into advisement in this consideration, even with comment, as you work within the restrictions of the regulations. But I certainly think it comes to town meeting and the planning board, and I would certainly say, and I'm sure there are some others who would echo, that the laws don't match the situation here. The zoning doesn't match the real situation of the character of the neighborhood, and that seems to be a structural flaw with this decision-making process, because it is a quasi-commercial neighborhood and always has been, from when Brayton's was a blacksmith to now it being a garage. So I think that's a bit of frustration for everybody. I think the other thing to keep in mind, I've heard some things about the use of the parking lot and the lot. When Mr. Geld was alive and renting this to Mary Miska to start Gray's Daily Grind, he certainly knew about that being used as a parking lot, and there was a sign at that time, parking for Gray's Daily Grind. So just to take a little of the onus off the current owners, that there was precedent even when Mr. Geld was alive for that usage. And I think that the property was probably separated at his death when it was sold. So again, it wasn't some sort of malintent of Bruce and Sarah, but, I don't know the details, but it's sort of a bit of again, however that evolved, it doesn't seem to accurately match the actual use, even at that moment in time of that lot. So I wanted to just note that kind of cognitive dissonance and structural flaw in trying to make these decisions and have this conversation, and reiterate the value of potential village zoning. And if there's any way to factor that reality into this conversation, I think that would be valuable to most of the neighbors who support this. Thank you.
Yeah, just as a comment to that, officially this land is identified as residential.
I understand that.
I understand that whole area is commercial, but we have to go by what it's zoned as.
I understand your
And-
constraints, but there might be
and
room
that's
for
the quandary
comment.
that we're in.
Yeah, that's why I'm saying it's a structural flaw in the regulations and the reality.
Can I just add one more thing? Nicole Wardell, 29 Main Street. So if this is a residential property, so if someone pulls in a Winnebago from Sanford Road and has mold all over it, you'd rather see something like that sitting there than what's sitting there already?
But that happens all over town.
Yes, but this is Adamsville, it's historic.
Sorry, it happens all over town. Now, I can't segregate Adamsville from North Westport from any other part of the
They
town.
would need to get a permit to house a trailer there for any length of time.
You can have your own
The
trailer.
town bylaw, the town has two bylaws. One is
Town
for,
bylaws.
yeah, no,
General
it has,
bylaw.
no, it has a lot of bylaws, but it has two bylaws on trailers. One is for temporary trailers,
Right.
from summertime, May to November. And then there's another one from
It's
mobile.
seasonal,
Yeah,
and then there's emergency. Somebody's house burns down and they need to put it's not legal to have a mobile home, unlike Little Compton, for example.
Yeah.
and
We
this.
can't
this-
have mobile homes in
And-
Westport, but if your house burned down and you needed to put one in, you could go to the selectmen and get a special permit for a period of time, 6 months or a year, and and you could put your trailer, so there's different types of.
Yes.
But at the same time, we keep bringing it up that, well, Jerry does, we need to change the bylaw. There is no bylaw for food trucks or this kind of deal right here.
Right.
I researched everything this morning, took my entire morning away from my cows and everything else, but
So if everyone here is saying that we're in front of the wrong board right now, or we're not in front of the right people to make the decision, isn't there,
No.
No, you're in front of the right board.
but you
Well,
just,
except for the special permit part of this.
and that person wouldn't have been able to come here?
No, the special permit is a planning board task, not a,
And they
they
did
can
go-
issue the permit, but they can't issue it on the use.
right.
Right.
We're the only ones that can issue it.
That's where,
on the
that's where the variance comes in. They want to change the use.
They did go there to the planning board last night, and they got approved,
For the
But-
site plan.
For the site plan.
right, for the site plan, which is what it says in the zoning board. That's all it says in the zoning.
Right.
But some of us don't believe that that's the right part of the bylaw. That bylaw doesn't affect this, is the contention that was made.
Yeah. Well, I agree with the last speaker too, that maybe it's best if it goes into a certain village zoning, because, I mean, just to sell breakfast sandwiches out of a little tiny Airstream it doesn't seem like that big of a deal. I understand that there's laws and the planning board has to agree with everything, and I understand all of this. But the thing is that business there brings people in for other businesses like myself. And I feel like every time Sarah and Bruce have tried to move forward with stuff there, they're constantly put like with the wall up, you know? That's what it seems like from the outside looking in.
Well, I wouldn't have any idea what you're talking about.
They've never been before us before.
Never been before
Never
us.
before here, no issues that we're aware of on any of that. So I don't think anybody's intentionally trying to
Yep.
put blocks in front of them.
All right, thank you.
Anyone else? Okay, so we're still discussing the use variance. Essentially, from the use being to allow a food truck use rather than a parking lot. One of the issues that's going to be is identifying a hardship other than it creates, let me see, how did they put it? Literal enforcement of the bylaw results in substantial hardship. What that means, I suppose, is hardship to the business. And that's not really what our bylaws are based on. Our bylaws are based on hardship, based on the land itself.
We recently approved a variance at 177 for the aquifer protection.
No, that was an
Well,
aquifer
I mean, I'm
protection
just
permit.
saying, can't we use the pond for this?
Well, that's, you could think about, I mean, that's the only thing that they mention in here that would be related to the land.
But they didn't argue that. They didn't argue that. They haven't brought it up. So, like, we're not to do their jobs for them by giving them,
Yeah, we're not putting words in their mouth.
Right. Any other comments from,
No.
no, it's not the,
David O'Brien, 374 Cornell Road. So a remedy before you tonight, in this one instance, is the variance, right? We can talk about the village zoning later on and get to town meeting, to Cynthia's point, and show up and get the government we vote for, right? So the one way to remedy their situation in Adamsville on that parking lot is you taking an affirmative vote for the variance. Is that correct?
I'm not really sure how it would,
What,
You want to run it by me again?
you're voting on three things, you potentially could vote on three things
Yes.
tonight. You're saying the planning board does the special permit, so
We
that's
can
off,
put that one aside.
that's out of your purview. The cease and desist is still alive.
Yes,
And the variance
Yes,
is also
use
still
variance,
alive.
yes.
The use variance. And you, as a board, can vote in this one instance to solve this issue tonight,
well, okay,
affirmative or negative.
yes, yes.
You can vote on this
Yes,
tonight.
Yes,
And then they can go on their merry way. If you were to vote in the affirmative for the variance,
correct,
they would then have to go back to the planning board to get the special permit.
yes,
Is that correct?
yes.
And if they were to do that,
Even though, but then we would still run in if we disagreed with the cease and desist aspect of this,
Yep.
then they still would be under a cease and desist order,
okay. So does the
even if
vari-
we approved the variance.
So that,
That makes it a little more complicated.
right. Okay. So an affirmative vote on the variance and you deciding that the cease and desist is no longer operative would be, as a proponent for the coffee shop and the ability to have the Airstream and sell sandwiches, that would be the cleanest way
Yes.
for me as a proponent for Grace. That would be the best result tonight.
Yes,
Okay.
yes.
I would like to clarify something also, and that is that the part of the bylaw, which I believe that Randy was using, was temporary trailer. Is that correct?
Yep.
Yeah, okay.
They said it qualifies as an accessory use to the, yeah.
Right, but it was only in the table of use. That's the only place you found it, correct?
Temp
Okay.
trailer.
All right, what I want to clarify is that we didn't always have a table of use in there. It was always the bylaw itself as voted word for word at town meeting. That's what the bylaw was. Quite a number of years ago, 20 years ago maybe, a couple of our secretaries in town, they were always getting questions about, was this, where to find this, and so forth, in the bylaws. So they decided that they were going to do this table of use thing. And I was a part of that in terms of clarifying things and clarifying bylaws and so forth, so I do remember it. But the concern that we had was that people were going to use the table of use, which is very abbreviated. It just gives things like temporary trailer, okay? So along with that table of use is wording. The chairman indicated earlier some of that wording, but the rest of that wording was that in the event of any question or definition, the narrative version of the bylaw, which was the original stuff, supersedes anything in the table of use. And that's where I personally have an issue with this one, where it just says table of use, temporary trailer. And someplace, there has to be the actual vote of town meeting. And that is what I want to see before I do it. And I've done a lot of research, hours of this week, trying to find some of that. Fortunately, some of it now is searchable on the computer, but some is not. And I'm sure that town meeting would not have approved a bylaw that just says temporary trailer, unless they somehow skipped over it or something. There would normally be a definition of temporary trailer. We don't even have that. So I'm not convinced that that is an accurate depiction of our bylaw, that table of use. But I can't say that until we've had more time to review what year, what town meeting passed that, if in fact it did, because I don't believe it ever got passed that way. We're not that sloppy typically with our bylaws. And so I don't feel that that's something that's, I'm going to base a whole reversal of a business zone, a business use on something like that, until I've had the opportunity to determine that. It was only very recently that Randy made that determination. So we're trying to find the bylaw.
You can tell Jerry's been on this here for a long time. When he can tell you 20 and 30 years ago this happened.
Yeah, I think it's a little separable, right? I think in one respect, but I think the two, we need to separate the two, right? Is a trailer allowed on the property by our zoning bylaws? I think it is, by the letter of our bylaws. I know you want to know the history. But then there's the issue of it's not just a trailer.
It's a food truck.
It's not a trailer to live in residential districts. It's a business.
It's a business.
Not about that at all.
So I think we can separate the two, that they can keep trailer there, but they can't run a business out of it. But,
Anyway, that's, any other comments before, any comments from the board? Then I'll entertain a motion to close the hearing.
This lady's
Oh, you have something. Come on, name and address.
Cindy Zembo, 587A River Road. Again, I want to echo, thanks for your volunteer work. I've been a volunteer in various things. It's thankless. It's your time. I appreciate it. I sit and listen to all of this, and I guess I just think, how does a young person starting out in business, there's no pathway? I mean, I don't know the Delanos well at all.
and it's not their only business, so it's not their only business. They're not a small family just starting a business. They have a very successful landscaping company. No, I'm not holding it, I am not holding it against them. I'm saying I don't want to use it as an excuse of you're saying, please be so kind to this young family who's just trying to start a business. That's not the truth.
Stop, ma'am. I'm going to stop. I'm not here to fight.
Only one at a time, please.
The landscaping business has nothing to do with this business.
But anybody who is starting a business does so in the business district. If you are running a business in a residential district, then
They
you have to
bought a
abide by
business.
rules.
They
of
bought a
residential district.
coffee shop. They bought an existing coffee shop.
And we're letting them run the coffee shop. we're not-
They now want to do something in a residential district. And if you want to run a business in a residential
So I
district.
wasn't,
You can't argue with the fact. The fact is, they want to run a business in a residential district.
you're not even letting me finish what
Go
I was
ahead.
going to
Go
say.
ahead.
But I think I won't because there's too much animosity, and I'm not here to
No,
fight.
no, I want to hear it. I want to hear it, please. Okay.
She tried talking, but the lady on the right won't let her.
Hey, I'm Sarah Henry, 2000
The
Boston
lady on the
Road.
right's voting.
Okay.
I'm talking, please.
Yes.
I just want to say they already had a business. They had a business. Bruce Delano owns Delano Landscaping. Sarah assists.
We know that. I'm just saying,
Okay.
I don't want to use the excuse.
Come on.
I'm just
One at a
trying
time.
to. I work at Gray's Daily Grind. I have been there since Mary was working there, and yes, it was a great coffee shop. It was a fine, quaint little business. When the Delanos bought it, they upgraded it. They brought more people in. They brought their community. They brought people from New Bedford, from Fairhaven, from Dartmouth. They brought people into Westport, got business. Simmons shut down. The barn shut down. What did they do? They put a food truck connecting to their business. It's connected to Gray's. It's connected to Gray's Daily Grind. It's the Coop with Gray's Daily Grind. They made that because the barn was shut down. They made it for the community, and they got an electrician. They got a permit. They got multiple permits. They didn't necessarily get the okay, but they assumed, oh, we got the electrical permit. We got the electrician stuff in the ground, whatever. They moved forward. They were excited. The community that were present, they were excited. And that's like, it's just so frustrating because I saw you in the shop. You were so rude. You were so rude to all of us. You were. I promise. I promise you were. Believe me, he was. And it was terrible. Like, he was just
Mr.
so
Souza
rude.
has a very difficult job.
But he walked in. It was the first time I ever saw this man, the first time he had ever walked in the building, and he just like anger. And it was just like, this is not how you welcome a new business owner. It was very rude. And I had been there with Mary, and he was never there. It was just like this whole thing, animosity from the start. So I just wanted to like say that there are issues, there have been issues, but I don't know, like cut them some slack. They're trying their best. It's for the community, truly. Any comments?
Could I ask you,
Of course.
what year did you start working there in that coffee shop?
2021, 2020,
20, okay, so
something like that.
more than 10 years ago, okay.
No, when Mary Misko was running it, Mr. Guild was alive still. His family visited. They gifted the Delanos a plant, signifying that they were open to the new opportunities. So,
I do, in counter to what you're saying, I would expect that they or an attorney should have looked at the background of the zoning and zoning hearings that previously taken place and so forth, and maybe that might have.
Definitely, but like I think they really just the barn closed and they were like, we got to do something.
Right, they just-
So they did it. They got the permits. Henry. Henry, Henry. First name Sarah.
Thank you.
Any other questions?
No, thank you. No one else? Okay. No, I guess not. Okay, I'll entertain a motion to close the hearing.
I'll make a motion to close the hearing.
Do I have a second?
Second.
Any discussion? All in favor, say aye.
Aye.
Aye. All opposed?
Aye.
You oppose?
You can say
Okay.
no.
Yes,
Let-
I'm opposed because of what I
think-
said earlier.
yes,
I really, I need time to research some of this, for me to be satisfied that we're dealing with the right thing here.
Okay, so we have 4 votes in affirmative, 1 in the negative. So we are closing, now the closing hearing just means we're going to discuss it. We don't take any information from the public. So we'll start off with the cease and desist
Oh,
order.
before we go there, Roger,
Oh, by the way, in order to, in both of these situations, in the administrative appeal and in the variance, it requires 4 votes to, in the affirmative.
did legal weigh in, what Jerry mentioned legal in the beginning. Did legal weigh in on this through you?
No, they only weighed in saying that that we can hold the hearing without the petitioner.
That's the only thing he
Yes,
advises us?
that's what we talked about. Discussion on cease and desist. Okay, I'll
Right.
start.
Okay, you can start.
Okay.
What did you say,
I mean, I-
Cynthia? I couldn't tell.
No, I'm
Since-
letting,
Allowing me to start.
I'm letting the chairman start.
And I've read, I mean, we've been through the use table several times, and we've used it in a couple of other different petitions, and I have to agree with Ralph. I don't see anything in there that says that we can run a food truck on residential property. It's, I have to agree that Ralph's interpretation is correct.
I agree in part. I agree with you that I think Ralph's interpretation was that we can run that is not in our zoning bylaws, to run a food service trailer. And I agree in part with our assistant, our interim building inspector, that says that a trailer, not a food trailer, is an acceptable
And that's where the
use.
special permit comes in.
Yeah.
Yes. But right now, we're just talking about the cease and desist for the food truck on residential property. And like I said,
Food trailer.
Food trailer.
So, just to clarify for the public, if we vote that Ralph was correct and they cannot operate a food service trailer, it does not mean that they are forever banned from operating a food service trailer. It means that what they need to do before they can reopen the trailer is to get the variance from us and then the special permit from the planning board.
Right.
So it is, by us voting in favor of, or agreeing with Ralph's initial cease and desist letter, doesn't mean we're saying to all of you that this business cannot exist. We're just saying that the business owners need to get other approval from the town before they can move forward.
Any other,
I want to say that I think whenever we discuss this, I think we should be saying food truck and true food trailer, because in some places they're
They call
calling
it
it a
truck,
trailer,
yes.
but it also says here, the applicant also seeks to operate a food truck
Truck.
on the lot. So I want to
It's a
make sure
trailer.
we
It's a
we
food
cover the
service trailer.
territory, or else they want to put a truck. No, you
Yeah.
can't do it, we got to go through all this again.
Yeah.
I want to deal with that. And I also agree, by the way, that Ralph did read it properly.
okay. Any other discussion? Okay, this is one of the situations where things sound a little bit negative. The petition is essentially to overrule the cease and desist order. So if we vote in the affirmative, we are agreeing with the petitioner that Ralph interpreted it incorrectly. So if we reject the petition for an administrative appeal, then we are saying that, no, we agree with the original cease and desist order. I just want to make sure we understand, because sometimes it's a little bit negative. What I generally try and do, and it's under the advisement of our lawyer, is we always tend to vote in the affirmative first, because it's less confusing. Our bylaw says I need 4 votes to approve. It doesn't say how many votes I need to reject. And it sort of sounds obvious, but legally it's not. So, anyway, a discussion before we take. Again, I'm going to make a motion to grant the petition on the administrative appeal, saying that Ralph was incorrect. Now, that's not a vote, that's a motion. Everybody understand that? Okay, do I have a second for the motion?
I'll second it.
Okay, the discussion before we discuss. Again, remember that a motion and vote are 2 separate things. So,
So let's be clear, in the affirmative, we are saying that Ralph did the wrong thing.
right, I need 4 people to put their hands up and in the affirmative, saying that Ralph was wrong. So
I
if
wanna
you
be clear.
don't put your hand up on the motion, then you're against that. So a show of hands for those who want to grant the petition for the cease and desist. All those who want to reject it, raise your hand. It's unanimous. Okay, so that's pretty obvious. So the cease and desist order stays in effect as far as the zoning board of appeals is concerned. Second part of this is the use, which is a little bit more complicated. Matter of fact, I'm going to skip though to get this out of the way. And I want to make a vote from the board to say that the special permit for the trailer allowed by the special permit planning board is not a zoning board issue. It's a planning board issue, and we shouldn't be acting on it here because we don't have authority to do that. And I want to make I'm going to make a vote to not act upon the special permit aspect of this because it's not within our jurisdiction to do so. Do I have a second?
I'll second that.
Discussion. All in favor, say aye.
Aye.
Aye. Jerry?
No, I'm going to abstain.
You're going to abstain. Well, that's, okay, so there's 4 votes. That only required a majority because it's not a voting on a petition, it's voting on a motion. So we are not going to act upon the special permit because, again, that's under our bylaws, that's a planning board requirement, not a zoning board. And if we were to act upon it, we would be acting out of our bounds. So,
I'd like to explain why I have to abstain.
Go ahead.
Because as I said earlier, I have not had the opportunity, the time, to research that, because this is assuming that I agree that that's the bylaw, and I don't.
Okay.
Because I just think it's too sloppy. I don't-
And we can't continue this here.
Well,
no, we can't. Okay, variance, discussion on the variance.
don't think they've met their burden to show a substantial hardship. So on its face, I would say I don't think we should vote for the variance. However, I think, I don't know if we can do this legally, is that if we deny the variance but without prejudice, so they can come back and reapply for the variance next week if they want to. Because if we deny the variance tonight, they can't come back to us for 2 years,
I
right?
don't think we can do that, can we do?
I'd like to give I would like to give based upon the support of the owners of the Daily Grind, in that I'd like to give the owners a benefit of the doubt of why they weren't here, and perhaps they got bad advice from council.
Yes,
But
don't
again, I
think
don't know
we
if we can do that.
I don't think we can do that. We either have to grant or reject. We can put conditions on it. Whenever we grant something, you can always put conditions on granting something. Rejecting is just rejecting. You don't reject with conditions.
But if we reject, they can't come back for 2 years.
If we reject them, they can't come back for 2 years,
And,
unless they go to court.
and I feel slightly differently for a different reason. They had every opportunity to be here tonight
Here,
to talk
yes.
about this, to go back and forth and so forth, and they chose, through their attorney's recommendation, that they feel that it's all set the way it is, the planning board thing is okay, even though last night, the planning board made it very clear that their approval of a site plan was not a green light for them to go ahead. Am I correct, Ray?
Yeah, yes. They said they could approve the site plan, but they couldn't approve the use.
Yeah. I mean,
That's on
and the
record.
attorney doesn't speak to the variance that was applied. They only speak to the cease and desist order. So again, I just think they got bad advice for not being here.
It's very unusual for us not to have an applicant, especially in advance.
It's never happened in my 10 years.
First time for me.
Yeah.
And we've had a lot of attorneys in front of us.
Yeah, they usually respect the fact that we're here, that they come even if they don't think they have to come.
By the way, I'll mention that in the lawyer letter, which we just got at 3:45 today, okay? About coming here or not coming here. And there was no mention whatsoever of Ralph's latest letter. Which
I don't believe they have it. I went to the planning board this morning and was under the impression that they didn't have Ralph's letter.
Do we have,
No, they have it.
what, again, I can never remember your name. Randy, we have what Randy wrote?
Yeah.
Can I see that?
It's attached to the attorney's letter.
Okay.
Mr. Chair, can I just say something?
Yes.
When Ralph issued, it wasn't a letter, it was an email, just reiterating
Yes.
his cease and desist. It was sent to Michael Burris yesterday.
No. Michael said he had it. I'm talking about their attorney having it.
No, it
I
didn't
don't
go to
know,
anyone
there's no
else.
way of knowing that.
Didn't go to them.
Your town,
Didn't go to them.
they found out
I
last
didn't
night
get
at the
it
planning
either. I
board.
found out today.
Well, that would be.
Michael said that he didn't believe that the attorney had it. Even at the meeting last night when they were discussing it.
Yeah.
It looked like he was like, wow, I don't know anything about that.
Yeah. What gets me is in the, Randy didn't say they could operate the temporary trailer. That is, he is just stating that, or no, you say it's accessory use, right? So you did two things. You said that the temporary trailer is allowed on the residential district, and you believe that the,
It's an accessory use to the parking lot, which is part of the business, which is allowed. That's how I came to that conclusion.
okay.
Yeah.
Okay, based on what I just heard, which I did not know, about the thing, I would go along with your argument that maybe we should give them the opportunity to come back.
We can't?
We can't.
If we can.
This is either.
Unless we can, then we can't even continue it because they're not here.
And then we can't continue it because we closed the hearing.
Yeah.
Can we reopen it?
We can, but I don't know what good that would do with the attorney saying that they believe that that we have no authority to do anything.
Why can't we make the decision without prejudice?
I don't know what,
Because if we deny something, we can deny it.
With prejudice, so I think
Yeah, with or
it's
without prejudice.
prejudice.
Uh,
I think we can
Go
do,
with prejudice, so they can't come back. So I'm
not
just
sure.
asking the
yeah.
question. Is that-
Again, I don't know, because we usually deny with but I think we can deny without prejudice.
Right,
What does that mean? That they can
well, that
come
means.
They can come back.
that means They can come back tomorrow.
yeah.
But
We do
I'm
that
in
on-
agreement with that.
We do that on
I'm in agreement with that.
withdrawals.
can they, you're not sure? So, okay,
That's what I'm wondering, it's just,
I mean, the worst-case scenario, right, is that we deny it without prejudice, and we're wrong that we couldn't do that, and then we just denied it and they have to go to court, right? But who's going to argue that, unless, we get advice from counsel that we did something incorrect, they're not going to argue that we did it incorrectly.
Because it still gives them a chance to come back.
Come back.
yeah.
Right.
So, like, if we do something wrong, it only ends, it basically does what we're probably, I mean, I don't know, I'm not gonna speak for myself, but I don't think the fact that they're next to a pond is a substantial hardship. As Jerry was, I think, saying earlier, and I think Ray was saying earlier, there's lots of reasons why there's a substantial hardship here. But we're not gonna make that argument for them, because we shouldn't. But I would like to give them the opportunity to come and make those arguments.
We don't usually do a denial with or without prejudice. We usually reserve that for withdrawals.
Yeah.
We'll withdraw without prejudice, and with the
Right.
idea that they've indicated to us they're gonna come back. And so we're letting them come back sooner. But what happens in probably 90% of the cases, we never see them again. They just go and do what they wanted to do anyway.
But if we can withdraw without prejudice, I'm not sure that why we can't deny. I don't know. We've never done, that's, I mean, I like the concept.
So I really would, we've got a lot of people here
I like the
that
concept
support,
because.
And I'd like to hear
It doesn't close the
them.
door on things, it just keeps things moving,
and then,
potentially.
but we don't know if we can do that.
Well,
but we don't do, then we just
But
basically,
what if we say yes?
slap my hand and,
But
It's
what
with
happens
my
to
tag.
them?
then
They're
can't come back for
screwed.
2 more years, right?
So why do we take that chance? Why don't we just go, all right, you get the variance?
No, because they haven't proven that there's a substantial hardship. We still may deny it, right? But I personally don't have enough information. What they have presented on the record does not, in my opinion, meet a substantial hardship, right? However, given the tremendous community support, I would like to give the applicants an opportunity to voice that.
Mr. Chair,
yes, Randy.
I just want to advise the board to proceed with caution on this, because if their attorney and they were not aware of Ralph's email.
Right.
And this is the only thing they're going by.
They were
And
aware,
they're-
there's a video
Hold
of
on,
big,
hold on, okay. Then this is what they're going by and could be the reason why they're not here.
Right.
So I would just exercise caution with whatever decision you guys make, because I don't know if legally they were notified of Ralph's email. So I just want to throw that out there.
Okay,
Well,
I'm not sure how relevant that is.
I
but
just want-
I
It's just
understand.
all,
I just want to
Yes.
say something about
Procedural.
that.
Right.
I believe that, well, they were there at the planning board meeting last night.
Yeah, they were there.
yeah.
yeah.
They
so-
know that happened.
The next half of
And
that.
that's just a cease and desist.
I don't know.
That,
Whatever.
that was
He
only,
was keeping her,
Nothing
Yeah.
to do with the variance.
yeah, nothing to do with the variance.
yeah, I just advise whatever, you
Yeah.
guys do whatever you want.
Yeah.
No, that's right. But you probably weren't aware that they were there last night.
No, I knew they were there.
When I say they were there, I'm talking about their attorney was there with the female owner.
I guess the other thing they could do is reopen the hearing and have one of their employees ask for continuance.
Yeah, the only issue with that is, then they come back and say, we're still not coming because we don't think that we need to.
Right.
I mean, that was the.
Then we come back, and then we just vote, then we just vote at the next meeting.
I think we've gone past that point.
Yeah. I mean, it's unfortunate they're not here.
This was written and delivered to us today. They knew last night that Ralph had overturned the overturn.
Right.
And in an abundance of caution, I would have still showed up tonight, the attorney. I mean, because, I just, the fact that they sent a letter to us at, well, it was 2:45 to Maria, and then time we got it was that, and just assume that it's not necessary, and not at least come to at least, hear what we had to say. I mean, I
We're just happy that this many people are here.
yeah, we never had these many people here. Well,
Okay, so if we give them the variance for this one thing, they still have two negatives.
No.
they still need a special permit from the planning board.
So that even if we give the variance, they can't operate the food truck or food.
Ralph, okay, so.
No.
Enlighten me upon that. We give it, if we uphold the cease and desist,
Yep.
and we approve the variance, what does that result in?
Approve the variance of what, with the trailer there?
The change of use.
Change of use, that means you're letting them operate.
Right, so that nullifies your cease and desist. Right.
I don't think we have a choice but to deny this.
It does not say that Ralph was incorrect.
Right. We're just
It's simply
overruling.
that now because you've convinced us that you have the hardship and we grant that variance.
Right.
And so he was correct at the time that he did that.
Yeah.
I want to be clear.
Mr. Chair, just for the record, as soon as I got the letter, I contacted the attorney right away. I was put on hold for about 10 minutes. The girl kept coming back, oh, hold on. And then I was finally told that he was in a meeting. So I left my name and number, and I have yet to get a phone call back. So I never did get to speak with him, because I was gonna suggest that he should probably come anyway, which I've been telling him for the last 3 weeks.
Right.
We've been going back and forth on this.
I said, I'll see you tomorrow night on the way out of the planning board meeting. And she said, yeah, I'll see you tomorrow night. I actually opened the door for her, let her know.
Ooh, according to Google, you can deny a variance without prejudice.
Okay. Does anybody want to make a motion?
Does that
I
Google
mean,
law?
Does it, no, I'm saying, well, it's to your favor, we're trying to do something to their favor, so we're trying to, we want to give them the benefit of the doubt that they did not come here tonight on bad advice of counsel, okay?
variance, you're given the benefit of the doubt.
No,
That's another story.
no, that's not giving.
We can't, because then everybody else who wants a variance is going to ask for the same thing.
Yes. Make a motion.
I make a motion to,
In this case, we're going to do grant because you're going to put a condition on it. So, I mean, not grant, you're going to do,
well,
Go
you
ahead.
gotta,
go ahead.
I make
You make a motion to reject with a,
I make a motion to reject the petition for a variance without prejudice.
okay, so what you need, okay, yeah,
And they can either decide to
Yes.
come, or they can decide to sue.
right. I second it. Discussion. Again, we need,
Do we have to?
again,
make-
this is a reverse because we're rejecting. So we're going to need 4 positive votes, which means, if 2 people vote for this, then the variance fails. No discussion? Okay, did we have a second? Oh, I seconded.
you seconded it.
I did, okay,
So we vote yes, that means it fails.
Again, all in favor of rejecting
Rejecting-
prejudice.
without prejudice,
So so a yes would mean that,
so that then they can reapply.
Do we have to read this entire,
No, because it's not even in here,
well, the variance part's in
the
there.
variances. So we were rejecting a variance from Article 6, zoning bylaw, Section 5.1, Table of Use Regulations. Okay,
We have a motion and a
there's a
second.
motion to reject and a second to reject. All in
Without
favor
prejudice.
of rejecting, raise your hand.
Without prejudice.
Without prejudice. That's 4. All opposed, 1. It's 4-1. So the variance is rejected with prejudice, which means they can reapply at any time.
Without prejudice.
Oh,
Without prejudice.
Right. So it's up to them. They can either reapply to us, for variance, or they can,
Then they can come back and
or they
show
can
us
not show up
why there's a hardship, why this actually fits in.
and take it to court, right? So it's really in their court of what they want to do.
So, that concludes the, and again, I say it's 20 days, but there's nobody here to, no, there is a 20-day appeal process. Thank you all for showing up. We really, this is really important to hear from everybody.
I still would like the opportunity, if they were to come back, I certainly hope I have the opportunity to dig deeper into this bylaw and see what the narrative says.
I think there are two things. They either need a variance and they don't need a variance,
Yeah.
right? Depending on.
Yeah, right.
I don't-
If they made clear of our bylaws that it's meant to be, and they don't need a variance, and that's fine, right? Or they need a variance.
Okay,
Either way, we get to discuss that.
So we would get to discuss it.
okay, next order of business is meeting minutes, February, by the way, Randy and Ralph, thank you both for coming. I mean, it's, you know, we really couldn't have done this without you guys, both of you guys today.
Let us muddy.
And Randy, you know, and,
So what else, muddying it up?
no, it's, well, zoning is always muddy.
Oh, yeah.
It's,
So you, staying on, help him out, or
Nope.
are you gonna, or moving on?
Nope. Him and Jim want me out, so I'm leaving as soon as he's back.
really,
It's the truth.
Is that for real?
Yeah,
That's for real?
yeah, well,
it is what it is.
it is what it is. Thank you anyway, thanks,
Yeah.
Randy. We
There's
appreciate.
nothing personal here. I hope you guys know that.
No,
Yeah,
no,
just my
no.
opinion, like whatever you guys want to think.
You know, and, you know, it's tough because we put you in a situation where, you know,
Well,
these zoning bylaws are really difficult to read and understand, and, you know, Ralph's been doing it for 15 years.
I know. That's why you've never seen that before, because you've had Ralph here forever.
Right.
You've never seen anything overturned or had someone else come in. You know what I
I'm
mean?
sure, listen, I've seen it.
We
I
have.
went from Maltese to him,
Yes.
right?
Yeah.
Yeah,
But anytime there's a new guy in, here you go. What do you think? What do you think?
it's gotta be tough. Yeah, because, you know, how can you really do the intricacies of every word in that zoning bylaw? You know, I've been doing this for 10 years and I still don't know half of it.
You do a better job.
Thanks, Ed.
Again, like, because we have the antiquated system here in Westport, where it's on paper, you're at a disadvantage coming in because you don't have all the history of the property.
Showed up in
Oh,
the
yeah.
bylaw.
I mean, I was just going based on the facts that I had and talking, you know what I mean?
Mm-hmm.
And that was just my opinion.
Yeah.
Like I said.
Yeah,
Falls
everybody
on you
has one.
guys. Yeah.
Yep.
So that was my interpretation. You guys disagree with it? No problem.
Yeah.
I don't take it personally. It doesn't matter.
Thank you.
All right?
Okay, meeting minutes, February 19th. February 19th, 2025. Maria generated the meeting minutes, and they've all been reviewed and edited, and I make a motion to approve the February 19th, 2025 meeting minutes. Do I have a second?
I'll second that.
All in favor, say aye.
Aye.
Aye. All opposed, no. That's unanimous. Same with February 26th, 2025. Maria generated these meeting minutes. This was,
I won't vote on either one because I,
no, so anyway,
The 19th, February 19th.
this is the 26th, so I make a motion to approve the meeting minutes for February 26, 2025.
Second.
All in favor, say aye.
Aye.
Aye. Opposed, no. That's approved. Any other business? There was nothing on the agenda. That's, I did look, I did,
April 9th.
April 9th, which is week after next. I did get a copy of, I talked to Paula this past week and got a copy of the articles that are going on the next town vote for zoning, to make sure that in fact it represented what the committees had done. And the select board had to actually include their own, because they're responsible for the general bylaw. We gave them a write-up that they used. So there will be 3 issues on the ballot for the town meeting. One of them is, actually 2 of them are short-term rentals. One of them is a zoning bylaw aspect of it, and the other is a general bylaw aspect of short-term rentals. And the third is accessory apartments and complying with state and federal, state laws.
Did they have an open meeting again after this short-term rental?
Did they ever what?
Did they ever have an open meeting once the select board was okay with it? Did they ever have the
Yes.
planning board ever have an open meeting?
Yes, they did. Yeah.
Missed that one.
Yes, oh, yeah, I went to it. yes.
Oh, missed it.
They did. So, any other?
I have a question.
Yep.
Someone asked, remember, I have very bad hearing. Someone asked the assistant here if he's staying on.
Yeah, I
He
did.
said no, but then everybody laughed. What,
Because Ralph and Jim don't want him here.
Can we talk about this?
Ralph and Jim, what?
Doesn't want him.
Oh, is that what he actually said? Okay. Wow.
I thought he needed an assistant.
Let's we talk about this after we close the hearing.
Yeah. Oh, I make a motion to close the meeting?
I
I make adjourn the meeting?
I
Are we not done
second.
yet?
That's it. All in favor?
Aye.
Aye.